Okay, let's talk about lawsuits for a moment or two. When you incur an obligation, you sign a promissory note or make a commitment. If you can't afford to pay that, the creditor is going to try to collect from you. And that's natural. We would do the same thing. If you can't afford to pay it, then they can't just come and take you and shake you upside down and see what falls out. That's against the law. It's called battery. But that's not the point here. They have to go through a legal process that's called due process, which means they involve the state. They go to a court. They submit a complaint with the court. That's what lawyers call a lawsuit. And then the court issues a summons. And that summons says, you have to respond to this complaint. And if you don't, within 20 days, if you're served in the state, then we are going to enter a judgment against you, and the creditor then can try to garnish wages or seize assets. So the court has this summons and complaint. It gets filed with the court, and then it's given to a process server who brings it out to serve it on you at work, when you're out and about, or to serve it at your home. And they can serve it on any responsible person at your home, whether they're an adult that's visiting, or whether they're an adult that lives there with you, or whether they're a younger child that understands and could understand the importance of getting documents to you. Once they've served that lawsuit, then you have 20 days to respond, to file an answer. It's critical when you receive the lawsuit that you do 3 things. Read it first. Take a look and see what it says. Do you recognize the creditor? Do you recognize the fact pattern? Did you really do that, or did you really owe that? Make certain that they're not alleging that you did or said or committed to something that you didn't. Second of all, you need to take that copy of that lawsuit and you need to bring it into either our office or to another attorney's office to have them review it in terms of rights and obligations that you would have, and affirmative defenses that you would have that you need to raise in a timely fashion. Third of all, make certain that you don't just bury your head in the sand. I understand that being served with a lawsuit with everything else that's going on in your life will leave a pit in your stomach. It can become overwhelming. That's not a time to curl up in a ball and lay down in the fetal position and hope that it just goes away. It's not just going to go away. In fact, it's going to get worse. If you don't respond, if you don't take it to an attorney to find out what your legal rights are, where you're going to end up is with a default judgment against you, because what they will do is they'll file a notice of default with the court after 20 days, and the judge will render a default judgment against you for everything that was alleged. You might not have even ever owed that creditor. File a responsive pleading, especially on a credit card lawsuit, because what you'll find in many instances is that they don't have the documents to back up what's called their prima facie case. So if you're served with a lawsuit, make certain that you take action. The clock is ticking. Don't delay. Every single week I have clients who come in, they bow their head down, they're embarrassed that they didn't do anything, and I feel bad because when I look at the fact pattern, I see that they probably wouldn't need to come see me at all relative to a bankruptcy if they had simply defended this lawsuit down on its merits. Take action, take control of your financial situation. I know you've got a lot going on, but give us the chance and the opportunity to meet with you and tell you what your legal rights are. We'll look forward to seeing you in our office.